Good morning. This is Rajeshkumar. Today we are going to discuss a theory question on undue influence. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer. Let's start with the theory question. The law on undue influence is difficult to state clearly and even harder to justify. Discuss. The law on undue influence is an equitable doctrine designed to protect individuals who enter into contracts under fair pressure. While the law provides significant protection, it is often criticized for its complexity and lack of clear boundaries, making it difficult to apply consistently and justify fully. This analysis will examine both the descriptive elements of undue influence and critiques its challenges in terms of clarity and rationale. A type of undue influence. The court have historically divided undue influence into two categories. One is the actual undue influence and the presumed undue influence. This classification was first discussed in Alcott Skinner case in 1887 and further developed in Barclays Bank O'Brien in 1994 and further the Royal Bank of Scotland versus Edridge number 2 in 2001. What is actual undue influence? Actual influence requires proof that a party directly exerted undue pressure or influence to compel another into the transaction. In these cases, as seen in Lloyds Bank versus Burnley in 1975, the party alleging the undue influence must demonstrate that the contract was procured through unfair pressure. Whereas the presumed undue influence, on the other hand, shift the burden of proof. Here, the claimant must demonstrate a relationship of trust and confidence and that the transaction is unexplained or manifestly disadvantageous. This was established in cases like CIBC mortgages versus Pitt in 1993 and RBS versus Edridge in 2001 case. However, the Edridge also disapproved of the rigid classification such as the Class 2A and Class 2B distinction, calling for a more fluid interpretation of relationship involving presumed influence. In other words, the undue influence is an equitable doctrine enabling the contract to be set aside if one party has exerted wrongful influence over another. The doctrine aims to protect individuals from decisions that were not made freely or independently, often when there is a relationship of trust and reliance. Traditionally, the anti-influence is classified into two categories. That is the actual anti-influence and presumed anti-influence. The actual anti-influence involve explicit evidence of one party manipulating or pressure another, often with the intent to exploit. Presumed anti-influence, however, applies in relationship where there is a presumption of influence based on the nature of the relationship, example, the parent child, solicitor, and the client. In these cases, if the transaction appears to be manifestly disadvantageous, the burden shifts to the influencing party to prove that the influenced party's concerned was free and informed. In Alcott versus Skinner case, the court highlighted that the presumption of undue influence is in fiduciary relationships. Miss Alcott, influenced by her spiritual advisor transferred her property under the circumstances that lacked independent advice. The court set the transaction aside, illustrating how undue influence operates in contexts involving trust and dependency. This case established that once a presumption of undue influence arises, the influencer must disprove it by showing that the influenced party acted voluntarily. Whereas in the NatWest Bank versus Morgan case, the refined undue influence in a financial context, the court found that undue influence require more than mere relationship imbalance. The influence must be wrongful or abusive. In Morgan case, although there was a significant trust relationship between Mrs. Morgan and the bank manager, the court ultimately held that there was no undue influence since the bank action were within the ordinary commercial practice. This case underscored the necessity of proving abuse or improper conduct, thus narrowing the application of undue influence in financial relationships. In Royal Bank of Scotland versus ETRIDGE case, the House of Lords clarified the requirement for establishing undue influence, especially in cases where a bank is involved as a third party. The court held that banks must ensure independent advice for individuals entering the transactions influenced by close relationship. However, this case also recognized a need for clarity and consistency in undue influence cases, emphasizing the procedural steps that bank should follow to protect the parties from undue influence without imposing undue burdens on commercial transactions. What are the critics of doctrine complexity and justification? Despite these clarifications, the doctrine remains criticized for its ambiguity and difficulties in application, inherent ambiguity, and judicial discretion. Critics argue that undue influence lack a concrete definition, leading to inconsistent application across cases. The doctrine relies on the subjective standards such as abuse of trust or manifest disadvantage, means that its application often hinges on the judicial interpretation rather than a clear objective criteria. In Edridge, the Lord Nicholas acknowledged the difficulty of precisely defining the undue influence, noting that the varying circumstances in which influence can be exerted make it challenging to develop universal rules. This ambiguity can result in unpredictability, making it difficult for parties to anticipate the doctrine's application in their contractual dealings. What are the concerns over the autonomy and the protection balance? The anti-influence aims to protect individuals from exploitation, yet the doctrine application sometimes conflicts with the principles of contractual autonomy. Critics argue that by presuming influence in certain relationships, the law may override the restrict individuals' freedom to make decisions based on the personal trust. The criticism here is that while protecting vulnerable individuals is crucial, the doctrine risks infantilizing the adults in relationship traditionally seen as autonomous. Example spouses, if undue influence is presumed too readily. What are the challenges in justifying the doctrine application scope? The presumption of undue influence in relationships such as a parent-child or solicitor-client raises question of fairness and the scope. That doctrine assumes that the influence is inherently problematic in their relationship, but this generalization can lead to unwarranted intrusions into otherwise fair arrangements. Additionally, the subjective requirements transactions be manifestly disadvantageous can be difficult to apply as what constitutes a disadvantage may vary widely depending on personal circumstances and perspectives. Let's move on to the comparison with alternative doctrines. Other equitable doctrines such as duress and unconscionability provides remedies for unfair or coerced transactions, but with clear thresholds for applications. Duress, for example, requires a proof of illegitimate pressure that which it concerned, whereas unconscionability addresses the situation of gross inequality and unfair terms. Both these doctrines focus on concrete criteria rather than relational presumptions, arguably providing more predictable outcomes. In comparison, anti-influence focus on relational power dynamics may seem overly paternalistic and difficult to apply consistently. What are the difficulties in stating the law clearly? One of the major criticisms of undue influence is its lack of clarity. While the distinction between the actual and presumed undue influence exists, the application of these categories can be inconsistent. For instance, the actual undue influence is relatively straightforward as it requires proof of overt coercion. However, presumed undue influence often relies on abstract concepts of trust and confidence, which can vary widely depending on the relationship and context. The case of NatWest versus Morgan in 1985 exemplifies this ambiguity. Here, the court refused to find undue influence in a situation involving a wife signing a guarantee for her husband's debts. Despite a claim of emotional pressure, the court emphasized that a manifestly unfair transaction was not enough to presume undue influence unless there was a clear evidence of improper conduct. This contrasts with Orbius versus Edridge in 2001 decision, which established that in certain relationships, such as between spouses, the threshold for presumed undue influence might be met simply by showing a substantial imbalance in the transaction. What are the critics? The difficulty in justifying undue influence stems from the balance court strikes between protecting vulnerable parties and maintaining the contractual freedom. The undue influence is based on equitable principles aiming to prevent the abuse of trust and ensure fairness. However, critics argue that doctrine's reliance on subjective relationship and vague concepts like manifest disadvantage makes it harder to apply objectively. In Alcott versus Skinner case in 1887, the presumption of undue influence was applied due to the close religious relationship between a nun and her supervisor. However, the lack of clear standards regarding when the trust becomes undue influence makes it difficult to justify why certain relationship automatically gives rise to this. Additionally, RBS versus Edridge case in 2001 shows that Ongoing challenges in applying this doctrine as the House of Lords attempted to provide more guidance to bank dealings with cases of undue influence. Banks are now expected to ensure that independent legal advice is given to those at risk of undue influence, such as wives as standing surety for their husband's debt. While this seeks to add certainty, it has been criticized for placing a heavy burden on the third parties, such as banks, to anticipate and prevent undue influence rather than focusing solely on the relationship between the contracting parties. What are the inconsistent applications and problems in the practices? The inconsistent application of undue influence further complicates its practical use. The division between the actual and the presumed undue influence often lead to different outcomes in similar cases. For instance, in Lloyds Bank versus Bernanke in 1975, the court found the actual undue influence due to the elderly claimant's heavy reliance on the bank for financial advice. However, in NatWest versus Morgan, where a wife was similarly pressured into a contract, no undue influence was found. This inconsistency has made it difficult to justify when the court should intervene in the private contractual relationship. Moreover, undue influence broadens, covering everything from overt coercion to subtle emotional pressure, makes it challenging to apply fairly. In situations like Barclay Banks versus O'Brien in 1993, where a wife claimed to have been misled into signing a security for her husband's business debts, the court had to carefully balance the need to protect the vulnerable parties against the risk of undermining the finality of the contracts. Let's conclude. While the law of undue influence serves an important role in protecting the individual from entering into the contract under unfair pressure, it remains a difficult doctrine to state clearly and justify in practice. The fluid boundaries between the actual and presumed undue influence combined with inconsistent case law make it a challenging area for the courts to navigate. Although reforms in RBS versus Edridge have added some clarity, the inherent tension between the equitable protection and contractual freedom continues to pose difficult in its applications. In other words, the doctrine of undue influence, while essential for safeguarding the individual against the manipulation in trust-based relationship, indeed, they faces criticism for its complexity and lack of clear criteria. The case law demonstrates attempts to clarify the undue influence, especially in the ETRIDGE, yet the doctrine remains fraught with subjective and variable standards that challenge consistent application. A clearer, perhaps narrower definition might help reconcile undue influences, protective aims with principles of autonomy and legal certainty, potentially aligning it more closely with doctrine like duress and unconscionability for a more balanced approach to the equitable relief. Thank you.